Hi everyone, welcome to the session on weekly legal news update. In this session, we discuss the important legal developments, anything that is of relevance for your common law admission test, other law entrance examinations, the things that are in news. So today's session is about how a governor can be removed because recently the DMK party has asked the Tamil Nadu government to be removed. So, what is the procedure? What does the Constitution say? What does the Supreme Court ruling say? What does various commissions say? So, we'll discuss all that in the light of the current development that the Tamil Nadu government is being trying to stay while the DMK party wants him gone. So let's see what is the development and what is the issue. Just one second. So DMK wants Tamil Nadu government gone, a governor gone. What does the law say on how a governor can be sacked? So as you know, the DMK leader is T.R. Balu, and the governor of Tamil Nadu is R.N. Ravi. So T.R. Balu has urged all like-minded MPs, not only DMK leaders, but all the member of parliaments who think the same as the DMK leader is saying, to support a proposal to remove Tamil Nadu Governor R.N. Ravi. So, how are governors removed from office? Like for president, we have the impeachment process. But what is there for governor? Well, how to remove a governor? What is the procedure prescribed if DMK leader wants him removed? What he has to do? So, what that is what we are going to discuss in today's session. So, DMK, the full form of DMK is Dravid Munnetra Kashkam. Dravid Munnetra Kashkam leader T.R. Balu on Tuesday, November 1st, urged all like-minded MPs to support a proposal to remove the Tamil Nadu Governor R.N. Ravi. In a letter, Balu said, members of parliament belonging to DMK and like-minded political parties are requested to kindly visit Anna Arivalayam headquarters to read and sign in a memorandum addressed to the Honorable President of India. Who is the President of India? Draupadi Murmu, pertaining to the immediate withdrawal of the Governor of Tamil Nadu. See, Draupadi Murmu, we all know, is recently elected the president. But when we are discussing CLAT and other entrance examinations, all the important constitutional posts are very important. You should know who is Attorney General. You should know who is Comptroller Auditor General. So if you remember Draupadi Murmu, you should also remember Girish Chandra Murmu. GC Murmu is the Comptroller and Auditor General. If you know the President, you should also know the Vice President, that is Jagdeep Dhankar. So who is the President, who is the Vice President, who is Comptroller Auditor General, who is Chief Election Commissioner, who is Attorney General. These are some important constitutional posts that all the aspirants of CLAT and other law entrance examinations should be aware of. So he says that uh, memorandum addressed to Honorable President of India pertaining to the immediate withdrawal of the Governor of Tamil Nadu. The proposal is to be addressed to President Draupadi Murmu. The DMK's call for removal comes when governors in several non-BJP ruled states, including Kerala and Punjab, had expressed disagreements with the government on various issues. Now, see, why does it say non-BJP ruled states? Because, as you know, that in the center we have the BJP government. And who is a governor? Governor, in a way, represents union in the respective states. So, he is a representation of the union government in the state of which he is the governor. So it is not, although he is considered as a neutral person, he does not favor any party, does not belong to any party, but he, in a sense, is reporting to the union and representing union in the state. That is why this thing has been mentioned that several non-BJP ruled states, including Kerala and Punjab, they have expressed disagreements with the government on various issues. Now, can a state government request the removal of the governor? And how is the governor appointed? And how can she be sacked? This is very important. The appointment of governor, what does the constitution say? And what does the constitution say about the removal of the government? Let's look at the provisions. These are very important articles. Article 155, just one second. Article 155 and Article 156 of the Constitution. A governor is appointed by the president. This is again important factual information, and holds office during the pleasure of the president. So as long as president is happy with the governor is holding the post. If the president wants, can remove the governor. So during the pleasure of the president, it's not a fixed term. It's not that once a governor has been appointed, he will remain there for 5 years. If the president does not want, president can remove the governor. So it's during the pleasure of the president. If this pleasure is withdrawn before the completion of the 5 year term, the governor has to step down. As the President works on the aid and advice of the Prime Minister and the Council of Ministers, in effect, the governor can be appointed and removed by the central government. So, as I told you, that governor is in a sense a representative of the central government of the union. So, that is why governor holds office at the during the pleasure of the president. So, president can remove governor anytime. And the president, how does the president works on the aid and advice of the prime minister and council of ministers. So these are the main people that aid and advise the president, that should we remove the governor, should you not remove the governor, and things regarding that. So in effect, the governor can be appointed and removed by the central government. In effect, technically speaking, it's the president, but in effect it's the central government. Thus, a governor is a representative of the union government in states. Article 163 of the Constitution says the governor will normally be aided and advised by the Council of Ministers, except in those functions which require his discretion. So, although the governor works on the aid and advice of the Council of Ministers, but there are some areas where the governor has some discretionary power. Some of the powers of the governor you must have heard about is the pardoning power, and some powers regarding giving assent to the bill, withholding the bill. So governor has some powers, but essentially works on the advice of the Council of Ministers. While the governor's duties and responsibilities lie in a particular state, there is no provision for impeaching the government. So, just like we have the impeachment process for the president, there is no provision for impeaching the governor. This is what it says. Although envisaged as an a political leader, a political head, so he is not related to any political party. He is apolitical, not political, who must act on the advice of the Council of Ministers. The governor enjoys certain powers granted under the Constitution, such as giving or withholding assent to a bill passed by the state legislature, assenting to the convening of the state legislative assembly, determining the time needed for a party to prove its majority, and which party must be called first to do so, generally after a hung verdict in an election. So these are certain powers that have been given to the governor by the Constitution. All these powers have been flashpoints recently, to cite two instances. When the Maharashtra governor had Devendra Fadnavis sworn in as the chief minister in 2019 amid a hung verdict, only for his government to fall in 80 hours. And when the Punjab governor in September refused to allow a special session of the assembly for a vote of confidence in the Aam Aadmi Party government. So the governor uses these powers, and these are two instances have been given in the recent past, one in 2019 and one recently. So governor has the powers to use discretion. Governor uses these powers. One example is of Maharashtra, one is of Punjab. So in light of this, how, to what extent his power exceeds, what are the limits to his power, and how can he be removed? That is the question. There is no provision laid down in the Constitution for the manner in which the governor and the state must engage publicly when there is a difference of opinion. See, there is bound to be a difference of opinion because governor is in a way representing union, and state government suppose has a different political party in power, and so what governor is saying, how the state government is functioning, there can be some uh, difference in opinion, if we can say. You must have realized this in, especially in Delhi, when where we have the Aam Aadmi Party government. Arvind Kejriwal always is in loggerheads with the lieutenant governor. He wants the full statehood of Delhi. He wants the police, and according to one of the recent bills, the government in Delhi will be called as the government. The lieutenant governor will be considered as the government of Delhi, not the chief minister. So, of course, Delhi is the capital, it's the UT. So, considering all these factors, governor has some powers, be it governor or even when I'm talking about lieutenant governor. So, they are, in a sense, representatives of the union. And in such a situation, there is bound to be some difference of opinion. The management of differences has traditionally been guided by respect for each other boundaries. Okay, we are respecting each other boundaries. That is traditionally that has been followed. So, what courts have said? What have these? What there has there been any judgment regarding that? That how what to do in such a situation if there is any difference of opinion between state and the governor, and how to move further. Since the governor holds office on the pleasure of the president, questions have been raised time and again on whether the government has any security of tenure. Because suppose the government is for 5 years and the governor has been appointed, so his term is of 5 years. So will he stay for the 5 years? Does he have that security of tenure? And if the president is obligated to show reasons for recalling a governor, if the president is withdrawing the pleasure, so does he have to give any explanation? Does he have to say why he is revoking him as a governor? Does he have to do that? So there is this one case, Surya Narayan Chaudhary versus Union of India. It's a 1981 case. The Rajasthan High Court held that the pleasure of the president was not justiciable. The governor had no security of tenure and can be removed at any time by the president withdrawing pleasure. So this was one judgment by one High Court. There has been a Supreme Court judgment also. See, High Court judgments are, of course, not binding on other High Courts or on the Supreme Court, of course, but they have a convincing value. When you will go to law schools, you will be participating in inter moot court competition, where you will be creating memo. You will be given a fact situation and a fictional situation, and you will have to prepare arguments for and against. And while preparing arguments, you will look for the relevant case laws. So you can use high court cases, but they will only have convincing value. If something happened in a particular case by a high court, a judgment is of high court, then that will not uh, be binding. It does not mean that if this happened in that case, so it should also happen in this case, because that is not binding. Unlike Supreme Court judgments, Supreme Court judgments are binding. So that is, you have to keep in mind that the Surya Narayan Chaudhary versus Union of India is a high court case. In BP Singhal versus Union of India, which is a Supreme Court case, and it's a 2010 case, elaborated what is this pleasure of doctrine? What is this pleasure doctrine? When we say use the word during the pleasure of president, what do we mean? It upheld that no limitations or restrictions are placed on the at pleasure doctrine. That president can remove a governor at the pleasure, and there are no limitations to it. He does not have to give any reasons, he does not have to say anything, justify anything. But that does not dispense with the need for a cause for withdrawal of the pleasure. So the second part of the judgment is very important, that limitation. See, first it is saying that any restriction or limitation is not placed at the doctrine, but there is a need for a cause for withdrawal. Some reason has to be there. Why are you withdrawing your pleasure? There is a governor functioning, and the president says that let's remove the governor. There has to be some cause. So you cannot totally dispense away with the need for a cause. That is important in BP Singhal versus Union of India. The ruling had come in response to a PIL. PIL is a public interest litigation. PIL filed by BJP leader BP Singhal, who had challenged the removal of the governors of Uttar Pradesh, Gujarat, Haryana, and Goa on 2nd May 2004 by the President on the advice of the newly formed UPA government. So, usually, when a new government comes, most of the governors are removed, most of the governors are changed. So, why were they changed? Why were they removed? Just because the president said that they should be removed, or is there any need for, is there any cause that is important? So you cannot totally dispense away with the need for a cause. The need for a cause can be asked. In his judgment, the bench, while noting that the president can remove the governor from office at any time without assigning any reason, without giving any opportunity to show cause, the power to remove can't be exercised in an arbitrary, capricious, or unreasonable manner. So, see, limitations and restrictions are being removed anytime without assigning any reason, without giving any opportunity. However, it should not be arbitrary, it should not be capricious, it should not be unreasonable. That is very important. The power will be exercised in rare and exceptional circumstances for valid and compelling reasons. A governor cannot be removed on the ground that he is out of sync with the policies and ideologies of the union government or the party in power at the center. So, this cannot be the ground that governor is not in sync with our ideologies. That is why I'm removing him. So, of course, the union government would like to have the governors of their ideologies because, in a sense, it's representing the union. But this cannot be the reason, this cannot be the cause, cannot be the ground. Nor can it be removed on the ground that the union government has lost confidence in him. So, union government has lost confidence in him, this is not a ground. So, this was the ruling by the bench. In this case, BP Singhal versus Union of India. The bench held that the court will presume that the president had compelling and valid reasons for the removal. But if a sacked governor comes to the court, the center will have to justify its decision. So the court will presume, this will be the presumption. If a president is removing a governor, the court will presume that the president must have some valid and compelling reason to do so. This is the presumption. However, if it is challenged, if the governor challenges the removal, then what will happen? If a sacked governor comes to the court, the center will have to justify its decision, gives justification, why was he removed, then it give reasons. So the governor has the right to approach the court in case he is removed. So court will see whether it's arbitrary or not, capricious or not, reasonable or not. So it should not be arbitrary, capricious, or unreasonable. All that will be taken into consideration. After this 2010 case, in 2014, when the BJP government came to power, it was claimed that the central government was pushing governors to quit on their own instead of recalling them. In August 2014, the Supreme Court agreed to examine a petition by then Uttarakhand Governor Aziz Qureshi challenging the NDA government's push to make him quit the post. So this also went in 2014 when the new government came. So they were creating circumstances that the governors quit on their own. They were not asking the president to remove the governor. They were just creating such situations that governor will himself quit. So Supreme Court agreed to examine a petition that was filed by Uttarakhand governor and challenged the NDA government's push to make him quit the post. So they also that was also done. So these were some rulings. These were some of the things that happened. The steps taken by Supreme Court, steps taken by Rajasthan High Court. This is the position that what the courts think how a governor can be removed or what is the procedure, because there is no specific impeachment procedure given in the constitution regarding removal of governor. So there have been several various commissions that have also expressed opinions. Over the years, several panels and commissions have recommended reform in how governors are appointed and how they function, such as the Administrative Reforms Commission 1968, Sarkaria Commission 1988, and the National Commission to review the working of the Constitution headed by retired Chief Justice of India, M.N. Venkat Shalya in 2001. So three commissions are mentioned. The most important one is Sarkaria Commission. Sarkaria Commission had recommended that governors are not sacked before completing their 5-year tenure except in rare and compelling circumstances. This was the recommendation. See, whatever the committees recommend, it is not necessary that becomes a law, but they recommend. That was the recommendation. Recommendations have also been made for a provision to impeach the government by the assembly. So just like we have impeachment process for the Supreme Court judges, for the president, similar or something of the sort should also be there for the governor. This was the recommendation by Sarkaria committee. However, none of these have been implemented. So these recommendations were not implemented. They were only the recommendations that should not be sacked before 5 years, except in rare and compelling circumstances, and this impeachment process should be there. So this was the article regarding what the Supreme Court said, what the various commissions said, and when and how the governor can be sacked, in the sense it can be removed from being the governor of a state. So thank you so much. Hope your preparations are going fine. We'll come again with the next legal update regarding whatever is happening, the latest legal updates that is happening. And whenever anything of relevance happens, the legal aspect of it becomes very relevant for students who are preparing for CLAT and other entrance examinations, because that's how it comes in news. That's how it will come in your CLAT passages. So thank you so much. See you in the next session with the discussion on another hot topic.